Monday, Illinois' criminal justice system will undergo a sweeping overhaul. More than 2 years after the original bill became law, cash bail will be completely eliminated statewide.
In tonight's cover story, our political reporter Tamon Bradley takes you through the unprecedented changes coming to all of our courtrooms.
Rarely has an issue animated politicians and voters the way this one has. No cash bail. In Illinois, money is gone as a condition of pretrial release. So how's it going to work? On Monday in room 100 of the Layton Criminal Courthouse, history will be made. Mary Marubio is the presiding judge of the pretrial division of the Circuit Court of Cook County.
People who have recently been arrested and who are awaiting pretrial conditions will be coming here, receiving those conditions, and then being released from custody.
When those first proceedings begin, Illinois will become the first state to eliminate cash bail.
Will this law make us more or less safe?
So I believe it's going to make us more safe.
That's not everyone's view.
J.B. Pritzker's purge law has put you in danger.
Criticism of the no cash bail overhaul was harsh.
We have about 640 people in jail. Half of them would walk out on day one.
Supporters called the skepticism fear-mongering.
Keeping violent criminals in jail, not allowing them to have bail, but taking nonviolent criminals and saying that there's no reason for us to have to pay for you to sit in jail when you can't afford the few $100s to get out of jail.
After a challenge from virtually every state's attorney, Illinois' highest court upheld the law, paving the way for the new system to take effect. Here's how it works. Beginning Monday, police must issue citations for suspects accused of low-level misdemeanors. Those individuals will be given a court date and released. For more serious crimes, where a suspect is arrested and remains in police custody, a decision about pretrial release will go to the court. Conditions for release are set in an initial hearing. Then the prosecutor can request a defendant remain in jail. Witnesses are allowed and the victim will be notified.
The whole thing about money, the ability to having to pay money, just isn't a part of the scenario anymore.
Sharon Mitchell is the Cook County Public Defender.
Before the Pretrial Fairness Act, a judge could make a determination that a person is eligible for release, but they had to pay a certain amount of money. The new system basically makes a determination about whether somebody is eligible to be released, just like the old system, and then the judge just makes a yes or no decision.
The judge will issue a ruling after listening to arguments from the prosecutor and defense attorney.
We look at the person's background, and that includes prior convictions, even prior juvenile adjudications, past failures to appear, and we look at the nature and circumstances of the offense in front of us.
The law defines detention-eligible offenses. Some of them are domestic battery, stalking, predatory criminal sexual assault, violations of order of protection, most gun charges, and murder.
Some charges that themselves don't qualify for detention.
The law tweaks how police treat some suspects, enumerating offenses that require release. Among them, petty offenses, certain misdemeanors, people charged with burglary where no one is harmed, and battery without great bodily harm. But police maintain discretion to take a suspect into custody.
Even if the person is eligible to be cited and released, the officer can choose to take that person through the normal process. It gives law enforcement a little bit more flexibility and freedom over allocating the resources that they desperately need.
Rather than a defendant arguing they should be released awaiting trial, it's assumed that they will be. It's up to prosecutors to push for a defendant to remain behind bars.
The discretion is with the state to file that petition, and to be clear, that's the standard now.
Cook County State's Attorney Kim Fox, a strong supporter of the new system, says she believes no cash bail will lead to more violent offenders remaining in jail.
Since you've been in this job, you've argued for fewer people to be behind bars. How do you square keeping the public safe with your goal of fewer people in jail?
My goal has always been to have dangerous people in jail. I think what has happened is people have conflated that when I said that we want to reduce the jail population, I want to reduce it for those who don't belong there because they don't pose a risk to public safety. That's always been our goal, is that we need to make sure that that jail is housing those who we believe are a threat to public safety or pose a real flight risk.
As for those charged with low-level, nonviolent offenses, money will no longer be a condition of their pretrial release.
Quite frankly, it is pretty sad that for so long we made decisions about whether somebody should be detained based upon the money that they had in their pocket.
The access to cash, it really is a fundamental question about who has access to money. And we have seen throughout the country that blacks, and particularly poor blacks, have been disproportionately impacted.
Now that people who don't have the money, who are nonviolent, aren't being held because they don't have the money, and people who are violent or dangerous, who might have the means, can't pay for their way out of jail.
Starting on Monday at 12:01 a.m., anyone suspected of committing a crime will have their case put into the new system. People arrested before then or who are already being detained will have to petition the court for a hearing under the new rules. Tamon Bradley, WGN News.